Good afternoon. My name is David Jensen. I'm an attorney in New York, and I have been handling Second Amendment cases since shortly after McDonald versus Chicago came down in 2010. Some of the organizations I've represented are the Second Amendment Foundation, the National Rifle Association, the Liberal Gun Club, as well as more state and local level organizations throughout Massachusetts, Connecticut, New York, New Jersey, Maryland, and Illinois that I can even attempt to recall while standing here. In particular, at the present time, I am counsel on two petitions for writs of certiorari that are pending before the Supreme Court that raise the bearing arms issue. That's Gold versus Lipton out of the First Circuit concerning Massachusetts, and Cheeseman v. Palello out of the New Jersey State Court system concerning New Jersey. I'm also counsel on a case, Johnson versus Illinois State Police, that is currently pending oral argument before the Illinois Supreme Court. We won that case at the trial court level, a ruling of unconstitutionality, and the state attorney general appealed it directly to the state Supreme Court. So the topic here is winning firearms freedom, one lawsuit at a time. And what I'd like to address is simply, where are we at now? And in particular, where are we at on this issue of the right to bear arms? And the answer is, ask me again in 11 days. The reason that's the answer is that, in all candor, from where we're at right now, with the state of play in the federal circuit courts of appeals, we're not real likely to move the ball significantly down the field without some sort of decision from the U.S. Supreme Court that requires a reset of some of the decisions that have been handed down. In the 10 years or the 9.5 years since McDonald was decided, the Supreme Court has largely declined to get involved in right to bear arms cases, but earlier this year they granted certiorari in the case New York State Rifle and Pistol Association versus City of New York, which, while not squarely a right to bear arms case, concerns the validity of rules and regulations in the City of New York that effectively prohibit lawful or most lawful New York City gun owners from transporting their handguns outside the city, whether to a gun range, a second residence, whatever. So after they granted certiorari in that case, something kind of curious started to happen, which is that when cert petitions came in front of the court that challenged or that raised right to bear arms issues, they started sitting on them. Meaning, in the normal process of the Supreme Court, when the court is in session, they meet about once a week for what's called a conference session. And at that conference session, two of the most pertinent things they do, especially for this discussion, is they consider pending writs or petitions for writs of certiorari, pending cert petitions, and they also consider pending motions before the court. So what started happening is, in both Gold v. Lipton, the Massachusetts case I mentioned, as well as in Rogers v. Gruhl, which your friend of mine, Dan Schmutter, will probably talk about, when those cases went into conference, instead of issuing an order that certiorari is granted, certiorari is denied, they just did nothing, meaning the case is sitting there pending, and presumably the angle is that they're going to make some sort of an order after they've decided the New York City case. So what else happened? Well, it turns out the City of New York really did not want to go to the U.S. Supreme Court. So the city adopted new rules and regulations, and the legislature changed state law in a manner that may very well result in that case being moot. And then the city came in and filed a motion and said, you should dismiss it. It's moot. And that motion, the court is scheduled to consider at its next scheduled conference date, which is October 1, 10 days from now. Now, what also started happening is, in the Cheeseman versus Polio case I mentioned a few minutes ago, we filed a cert petition on that last summer, and the court took the extraordinary step of requesting a response from the New Jersey officials on the other side of the case before it had gone into conference, and then scheduled it for submission also at that October 1 conference. So, as things stand now, on Wednesday, October 1, they are presumably going to go into chambers. They're going to decide this pending motion to dismiss as moot, and then they are going to take a look at all of these cert petitions. There's at least 4 I know of that have stacked up, raising right to bear arms issues, and they are going to make some sort of a decision about what, if anything, they are going to do with it. So, where are we at? Ask me on October 2. Keep your fingers crossed until then. Thank you.